A very warm welcome to everyone. Today, I, Reeya Khanna, a legal intern under Lexis and Company, am here virtually to express my topic, summon trial and summary trial under the Indian legal system. Now, in the previous videos, I have already explained what is a trial, session trial, and warrant trial. In this particular series, we shall be understanding summon trial and summary trial. So let's take a look at a very brief introduction of summon trial and summary trial. So summon trial says that if the offense committed is punishable with less than 2 years of imprisonment, it is taken as a summons case. In respect of this offense, it is not necessary to frame charges. Summon is issued by the magistrate to the accused under section 204 clause 1a of the CRPC, and summons case means a case relating to an offense not being a warrant case. So the procedure to deal with such matter is provided under section 251 to section 259 of CRPC, which is not as serious or formal as other trials like session trial and warrant cases, either instituted on police report or the warrant cases instituted otherwise than on police report, which are the private cases, right? Now, the second trial that we are going to be talking today is summary trial. So summary trial are basically those trials in which cases are disposed of speedily with a simple procedure to follow, and recording of such trials are done summarily. In this particular trial, only small cases are taken in hand and complicated cases are reserved for summon and warrant trial. Now, let's take a look at the legal provisions for these particular trials under the Criminal Procedure Code. So, if we talk about summon cases, the procedure for trial of summon cases by magistrate, then the legal procedure code, the criminal procedural code has mentioned these types of trials under section 251 to section 259, and the legal provision for summary trial in the criminal procedure code has been mentioned under section 260 to section 265. Now, let us understand both these types of trials in great detail. So the first trial that we are going to cover is the procedure in summon trial. So chapter 20 of CRPC, starting with section 252 and ending with section 259, deals with the provisions governing the summon trial. Now, summon trial has two stages, right? First stage of trial is on the appearance of the accused in front of the magistrate. The particulars of the offense for which he is accused must be stated to him and must be asked him whether he pleads guilty for those offenses that he is charged with or not. This particular procedure has been established under section 251. Further, talking about section 253, when the summons have been issued to the accused under section 206 and he pleads guilty for the same without appearing in front of magistrate, he is transmitted to the magistrate by post or through messenger. He shall also specify about the fine in summons, but in case the accused does not accept his guilty plea, then the magistrate shall, with his discretionary power, sentence him to pay fine specified in his summons. Further, talking about case laws, in the case of Biru Ram versus Ishar Singh and others, section 253 of Criminal Code provides that nothing in this section shall be deemed to prevent a magistrate from discharging the accused at any previous stage of the case, if for reasons to be recorded by such magistrate, he considers the charge to be groundless. So, also procedure when not convicted under section 252 or section 203 is given in the act as, then in such a case, magistrate shall hear the prosecution and take the evidence as may be produced in support of the prosecution, or shall issue summons to any witness directing him to attend or to produce any document or other thing. Talking about the the second stage of trial under the summons trial is the stage of acquittal or the stage of conviction. If the magistrate is satisfied that the accused is guilty of the charges framed, then the magistrate shall convict the accused under section 252. And if the magistrate, after taking about the evidence, finds the accused not guilty, then he shall record an order of acquittal of the accused. Further, the power of court, the court also has the power to convert a summons case into warrant case under section 259 of CRPC. Let's talk about the procedure established by the Criminal Code of Procedure for summary trial. So chapter 21 of CRPC, starting with section 260 and ending with section 265L, deals with provisions of summon trial. The very foremost objective of summary trial is to dispose of the case speedily, and the procedure to be followed is same as the procedure specified under summons trial. If a sentence of fine not exceeding 200 rupees is passed, then no chance of the appeal is given. Further, in every case of summary trial, if the accused does not plead guilty, then the magistrate shall record the substance of evidence, and the judgment is delivered must also contain a brief statement of reason for coming to the particular finding, which is mentioned under section 264. Further, section 265 emphasizes that every record, that is the particulars mentioned in the evidence judgment, must be recorded in the language of the court. So that is all for the procedure established under the Criminal Code procedure for summons trial and for summary trial. Thank you so much.